So let's discuss battery of a police officer in Louisiana. What is battery of a police officer? Battery of a police officer is a battery committed without the consent of the victim when the offender has reasonable grounds to believe the victim is a police officer acting in the performance of his duty. So the defendant must have known or should have known that the victim was a police officer. But what's a battery? Well, battery is defined by Louisiana law as the intentional use of force or violence upon a person of another. Basically, it's touching somebody physically. It doesn't have to result in serious physical harm. It could be as simple as pushing somebody or even touching them. And now it's a little bit different than an assault. People get it confused sometimes, think batteries and assault are the same thing or similar, but it's not. Assault, on the other hand, is the reasonable apprehension of placing somebody in the position of where they think they're going to receive a battery, or it's attempting to commit a battery, and there's not actual physical contact, as opposed to battery, which there is physical contact. So the definition of a police officer, we all kind of know what a police officer is. It includes law enforcement officers that they could be federal, they could be correctional officers, sheriffs, state park wardens, probation, parole. Now, battery of a correctional officer, you see a lot of these cases in the prisons. So that will fall under this statute. Now, this charge, battery of police officer, it can either be a misdemeanor or it can be a felony. So let's talk about the misdemeanor grade. Basically, that's just battery of a police officer, basically just pushing an officer or hitting him, and he doesn't really get that hurt. That's going to be a misdemeanor. But it carries 15 days, no more than 6 months, without benefit of suspension of sentence. So if somebody's convicted of this charge, even though it's a misdemeanor, they have to do 15 days in jail. So it's not a good misdemeanor to get. Let's talk about one of the felony grades. Felony grade, it carries 1 year to 5 years in prison, and that's without benefit of probation or parole, suspension of sentence. This is when it's a correctional officer is the victim in the case, and so it's taken very seriously. Now here's the medical attention felony version of battery of a police officer. So if it's a regular battery of a police officer out on the streets, not in a correctional facility, and that officer has to get medical attention, that amps it up to a felony of 1 to 5 years. And 30 days of that sentence is without benefit of probation parole. So then the defendant would have to do 30 days in jail and get hit with a felony conviction. So if, for example, like this example down here where I say LSU football game, fan makes a disturbance, the officer's involved, and say the officer gets pushed or the fan pushes the officer and the officer falls down, scrapes his leg, needs medical attention. Well, I mean, that could very well be a felony battery of a police officer. So there's defenses to this charge. For example, there wasn't actually force applied, so there must be force. If it can be shown through evidence, witness testimony, or video that the officer was never even touched and he was just making it up, that can be a defense. Another defense is that it just wasn't intentional. Let's say that a defendant just fell into the officer committing what the officer thought was a battery, but there was no intent to even touch the officer. Or let's say there was a fight between two individuals, officers in the middle of it, and one individual was trying to hit the other one and hits the officer. Well, he wasn't trying to hit the actual police officer. So he wasn't committing a battery of a police officer. He was committing a battery, but not of a police officer. And also, maybe the battery was consensual. What if the officer says, let's go fight? Well, that's just like a regular boxing match. So that's consensual. So if the defendant hits the officer in that situation, well, I mean, the officer asked for it. And also, the defendant must have known or should have known that the victim was a police officer. So there's got to be some kind of proof that the defendant knew or should have known that the defendant was a police officer in his duty as a police officer. So if you've been charged with this crime or you got a family member that has, feel free to give me a call. I'm Carl Barkemeyer. I'm a criminal defense attorney in Louisiana. I handle these all throughout Louisiana. Thank you.